All right. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument in three cases this morning. First is 22-1149 Borgelt against the Austin Firefighters Association from Travis County and the Third Court of Appeals District. Then 2348 Ford Motor Company against Parks from Collin County and the Fifth Court of Appeals District. And finally 23447 Texas Windstorm Insurance Association against Prusky from Nueces County and the 13th Court of Appeals District. The court has allotted 20 minutes for each side in each of the cases, and we'll take a brief recess between them, concluding them before the lunch break. The arguments are being webcast live this morning and should be available in the court archives later. Justice Devine cannot be present this morning, but expects to participate in all of the cases argued. We're ready for argument in 22-1149.
May it please the court. Mr. Riches and Ms. Baumgardner will present for petitioners. Petitioners have reserved 5 minutes for rebuttal. Mr. Riches will open with the first 8 minutes and present rebuttal.
Good morning, and may it please the court. The Texas Constitution's gift clause prohibits, as this court put it, the application of public funds to private purposes. Now, at issue in this case is a government program that, simply put, takes individuals who are hired to work as government workers and releases them from those duties to work full-time for a private labor union. In other words, this program takes public resources and places them under the exclusive direction and control of a private organization to advance its own mission and pursue its own objectives. The modest requirements of the gift clause are these. Any government expenditure must serve a predominantly public purpose. The government must maintain sufficient control over the expenditure to ensure that a public purpose is accomplished. And the government must receive adequate consideration in exchange for the outlay of every public funds.
Are you arguing that we need to overturn our own precedent in Texas Municipal League for you to succeed?
No, Your Honor. The court in Texas Municipal League, as you're aware, applied a conjunctive test requiring both sufficient consideration or a non-gratuitous expenditure, and then the court went on to examine public purpose and the three prongs under public purpose, one of which overlaps somewhat with consideration. So no, the court, this is in fact a straightforward application of Texas Municipal League. The easiest way, however...
Do school vouchers pass the test under your view of it?
Yes, Your Honor, absolutely.
Why would that be?
So vouchers are a program that are broadly available to the general public and individual taxpayers. So the gift clause was enacted in order to prevent the allocation of public funds to private special interests. That is, unique individuals that are receiving some special government benefit that others aren't receiving or aren't qualified to receive. So this case would in no way implicate, tax programs and things like that that are broadly available to the public. There's also a number of textual exemptions to the gift clause for things like economic development and things like that.
What about health insurance? The firefighters collectively say we want health care as part of our compensation, and the government's directly contract with insurers to provide that health care. But in paying the health insurer has, benefits directly from that. They get paid for managing the program and providing those services to the firefighters. How is it different than what you have here?
Well,
The firefighters saying we want collective bargaining as part of our compensation, and we want as part of our compensation leave designated toward that purpose.
Well, I think this gets to a critical point, Your Honor. Release time, or ABL, Association Business Leave, is nothing like employee compensation. Individual employee compensation runs to that employee, him or herself, for services rendered. This is a gift that's directed to the AFA for the AFA to use however and whenever it sees fit.
If all members of the fire department were members of the AFA, would it be a different answer?
Potentially, Your Honor. The reason it would be slightly different in that case is because, and this is part of the problem with this being classified as compensation, if this is compensation to all employees, then we run head
If they're all
first.
union members, is it any different than Justice Bland's hypothetical about health insurance?
It is in this way. If it's compensation to everybody, it runs head first into a compelled speech and association problem under Janus. What the U.S. Supreme Court said in Janus is no employee can be forced to give up part of their compensation unless they've provided affirmative consent to do so. So if it's employees, if everybody was a member, it avoids the Janus problem. But that's part of the reason it can't be compensation to everybody.
Well, people opt out of health insurance, but government employers directly contract with, company Blue Cross Blue Shield, whomever, to manage their health care that they provide as a fringe benefit to their employees. How is that different?
Well, of course, but
Why
that's
is
because
that not a gift to the insurers?
Because the benefit is running to all employees. I understand that they may elect.
An employee can easily say, I'm not availing myself of this health insurance. I have it somewhere else, or I choose a different plan, or It doesn't necessarily run to all employees.
Well, I should say it is a part of compensation that is available to all employees. Here, you have an expenditure that's directed to the union specifically for the union to get to decide whether to use it and how to use it. And in fact, under the plain terms of the contract, this release time is directed to the union for any lawful association business activities.
But a health insurer decides, I'm going to pay these benefits for this health care and not for this other situation, it's not covered. I'm just trying to see the distinction.
Well, one other very important distinction, Your Honor, that is completely absent here is in that case, the government has entered into a contractually obligatory relationship to provide those benefits, where the health insurer says, we are going to provide these benefits on these terms, and we're obligated under the terms of the agreement to do so. Here, there is no contractual obligation for the AFA to perform any function beneficial to the public.
So that goes to the consideration element?
I'm sorry, Your Honor?
That goes to the valuable consideration element?
Yes, Your Honor, that's correct. And in fact, the Fifth Circuit just last month had occasion to look at this very issue in American Precision Ammunition, and there was a $150,000 gift for a business to locate within a city. And what the Fifth Circuit said was two important points. The first thing it said was, even though this is a really large contract, like this one is here, there is a smaller gift within this contract, the $150,000. The second thing the Fifth Circuit said, and this is critical, is that the parties are stuck with the terms of their own agreement. End of story. We can't have consideration that ipsy dixit, all of these things might happen, magically might happen. Those things must be in the terms of the agreement.
Would it be possible for the AFA maybe to be able to do some things that would be okay for a public purpose, and other things like, doing things with political action committees, or, going on fishing trips, or things that are clearly inappropriate? Is there room for that?
Oh, yes, Your Honor. What all the gift clause requires is that if the government's going to spend money, it's got to be for a predominantly public purpose, so it can't be a whole bunch of fishing trips and some things that are legitimate. There has to be contractual obligations. That's entirely absent here. So the contract, and this actually exists in other release time arrangements, where the contract says you can use this, but it has to be to meet with city officials, to help represent employees, to do these sorts of panels and things like that, and they're laid out very specifically. So there has to be contractual obligations, and then critically, there has to be control over those expenditures to ensure that a public purpose is actually accomplished. You can't just cut the employee loose and say, go do whatever it is you do, and then have no supervision, control, or direction over those
So
activities.
if I could go back to the question I asked about vouchers, and that was just one example. I mean, any sort of welfare program, what's the constitutional reason why that's not a problem? There are very few controls over what the recipient does with the money. Do we just not put that through this framework, or how do we analyze that?
We think it does fit in the framework. I mean, the purpose, as this court has said time and again, the purpose of the gift clause is to prevent the application of public funds to private special interests. And the reason they were put in place is during the westward expansion when railroads were being improperly subsidized. And so you don't have that same special interest abuse situation.
But that has nothing to do with the three elements. So where are we going with that, right? So you're saying if you don't meet the three elements, it's still okay if something else exists?
Well, I'm saying that
Or doesn't exist?
Textually, and the purpose the clause was put in place was not intended to apply to those, but the reason...
There wasn't welfare in the modern sense when these clauses were written, right? And I'm not sure why they don't prohibit gratuitous payments to individuals, which are now just a common feature of American government.
The reason with the voucher example, I think, is a clear one. You know, that is an individual taxpayer that has the ability to direct the expenditure. The Arizona Supreme Court looked at this very issue with what are called education savings accounts. And they said that because the individual taxpayer is the one that received the benefit and then had the ability to direct taxes they would otherwise pay, it wasn't a gift clause violation because they were already obligated to pay those taxes.
What about welfare?
The courts that have looked at it, and this court has never looked at the recipient, has said that essentially these are not special interest enrichment scenarios.
So gifts, but that gifts are okay because they seem sensible.
The distinction is that because they weren't intended to benefit a specific class of individuals or one specific private association or organization.
Aren't they intended to benefit a particular class of individuals, the needy?
That's true, Your Honor, yes. I'm just, that is how the courts have come down on it historically.
What's confusing me, and may I, Chief?
Yes.
So you've come with the argument of the three elements: public purpose, government control, and adequate consideration. But then when we raise questions about vouchers or welfare, you say, well, no, those three, I guess you're conceding those three are not met, right?
Well, Your Honor,
do vouchers need all three of those elements?
The vouchers are never an expenditure of public funds in the first instance, Your Honor, because the taxpayer, him or herself, is obligated to pay that amount of money anyway. So he or she is not receiving a special benefit.
That's just not true. I mean, many people receive these that don't pay any taxes at all.
So I don't, generally under the way the voucher program works is you have a taxpayer that's obligated to pay, and then they receive the benefit of whatever that taxpayer expenditure is. I would say, though, to these three elements, to these questions, a number of these programs will have in place requirements to ensure that the government control them, for example.
Sure, I don't doubt with vouchers or welfare there's a public purpose and government control, but I'm not sure where you're getting the consideration from.
Well, the consideration has to be sufficient, and I assume that the argument would be that so long as the recipient is complying with what the terms are of whatever the particular government program is, possibly it could satisfy that if there's contractual obligations in place on the recipient. But I think the devil would be in the details, and I don't think we need to reach those questions in this case because the absence of obligations is so clear, the absence of control is so clear, and the predominant purpose serves the union's purposes, not those of the taxpaying public.
Before you sit down, can you just confirm our jurisdiction? We're talking about an agreement that has long since expired, and you're now, I take it, asking for a declaration about a new agreement that's not in our record?
Your Honor, the new agreement is in the record. The state introduced it in its reply agreement. The city has adopted.
Link to the story about, or the release about it? Is that what you're talking about, or?
The actual terms of the agreement are in the state's reply, and we'll get you the record citation. The city has readopted the identical terms. The Fifth Circuit and other courts have said time and again, in the context of labor relations, because these agreements have short expiration terms, if the government readopts effectively the same terms, the court has jurisdiction to.
Capable of repetition sort of situation, is that the point?
Precisely, Your Honor, and we know it's capable of repetition because we've seen it happen time and again.
And then also, before you sit down, you've cited 4 provisions of the Constitution as the gift clause, but we have a gift clause in Article 11, Section 3 that's actually about local governments, and that's not one that you have focused on. Why is that?
That one would apply. I think the clearest example, though, is 52A, Your Honor, which prohibits the state from authorizing local governments to engage.
We're talking about the legislature generally in these other provisions. We have one that's only about local governments. Is there any difference in Article 11, Section 3?
The courts have always treated them the same for purposes of the test, Your Honor.
And then lastly, I still want to understand, if I can, from you, what is the test for determining what constitutes a public purpose?
There must be a predominant public purpose.
That sounds like you're answering my question with the very words that I've asked you to define.
So this court has never defined predominant, Your Honor, but that would mean.
Define public purpose first, and then
it would
how do we decide what it is? Do we defer to the cities? Do we have to decide it ourselves? Do we do it based on what we think is public purpose? Is there something external that we can look to that's objective? That's what I think we have to do. You can't give us an argument about public purpose and never tell us what that is or how the courts really determine what that is in a serious way.
Your Honor, the government would have, if it's going to spend money, it has to be something that advances a government interest for the most part. There can be incidental private beneficiaries like the insurance example. That's an incidental benefit, but the primary benefit is to provide insurance coverage.
Public purpose is a government interest. That's the definition you want us to use.
Is the expenditure serves a government interest in most of its application, the majority of its applications.
Okay. Can I ask you this then? What can we define as a government interest?
Something that serves the health and safety and welfare of the population as a whole.
And is that something that we decide as judges? Is it something that the political branches determine and we give deferential review to? Is it de novo? How do we do that?
In our view, it would be de novo review. The purpose.
Why is that?
Well, because the purpose of the gift clause is to prevent the popularly elected branches from giving special gifts and benefits to their preferred interests. And so if the gift clause is going to have force and effect, then this court has to determine whether or not a gift has occurred, particularly in a case where maybe there's some quid pro quo, and in a situation like this where the exclusive representative is negotiating with the city council, there's a very clear quid pro quo that can happen there. So it's appropriate for the courts to police that to ensure that the abuses the gift clause was intended to prevent don't occur.
Thank you.
Any other questions? Thank you, Mr. Riches.
Thank you.
We'll hear from the state.
Thank you, Mr. Chief Justice, and may it please the court. There's a lot going on in this case. The easiest way for the court to resolve the gift clause question is through a straightforward application of Texas Municipal League, as Mr. Riches just said, holding that there aren't constitutionally sufficient controls on association leaves use. So I'll start there. Controls for gift clause purposes need to be a couple of things. They need to be specifically tailored and they need to be actually binding. By specifically tailored, what we mean is just tailored to prevent a gift clause violation. So as this court said in Texas Municipal League, they need to be tailored to prevent against the application of public funds to non-predominantly public purposes or to prevent the gratuitous use of those funds. And by actually binding, we mean that the controls need to be external or somehow non-voluntary or not ad hoc.
So why doesn't Article 10 provide sufficient controls? Because it directs permitted uses of the leave and says that the activities must directly support the mission of the department, and it requires the department official to sign off on the leave.
Well, I think the clearest example of how the provision doesn't provide sufficient controls is on the union president. That's probably the easiest way to see it. He gets 37% of the entire leave pool, but as your honors can see in the association leave provision, there are virtually no rules for how he can use that leave. Now, the city and union have put forward a couple of controls that they believe are sufficient, but they're not. For starters, the city and union have said that the union president is subject to generally applicable personnel policies and continuing education requirements, but those aren't specifically tailored to prevent a gift clause violation. They might control his conduct in other ways, but not in gift clause relevant ways. And then the city and union have also said that the union president meets with fire department management and takes calls from the fire chief. But there are a couple of problems with that. The first problem is that the city and union haven't pointed to any evidence showing that those things are binding, that he's required to do those things. And even if he was, they also haven't pointed to any evidence showing that at these meetings he's required to account for how he's using association leave. Now,
Is the union president exempt from the requirements in subsection B of Article 10 about the permitted uses of the leave?
it's hard to tell from a reading of the contract, Your Honor, because of course those things fall within the, fall under the provision that's talking about authorized representatives.
If he's not exempt from them, does that solve the problem?
No, Your Honor, it
If
doesn't.
he's not exempt from them and there's adequate documentation that all of the time is spent on them, would that solve the problem?
No, Your Honor, for a couple of reasons. The first reason is that some of the things that the provision regarding the authorized representatives, some of the things that they're permitted to do also don't serve a predominantly public purpose.
Which ones do you think serve the public purpose?
Well, as an initial matter, the association leave itself does not serve a predominantly public purpose, just as an initial matter, because the entire point of association leave, and we can see this from the face of the agreement, is to do things for the union. And that's, of course, the union is a private entity, and that.
But the limitations on what can be done with the ABL is not just anything that supports the union. It's an enumerated list, right?
That's right, Your Honor.
So there are some things that can be done on behalf of the union, not anything on behalf of the union. Which of those things would satisfy your view of what would be a predominant public purpose? Are there such things, or do you think it's just a null set?
No, Your Honor, we think not. The entire arrangement is unconstitutional because what it does is it takes these hours outside of the direct control of the city. The city can't tell the firefighters what to do with these leave hours. It can't say, you're on association leave, would you go and wash the fire truck or do something else for the fire department? It can't do that. And so what it's done is taken these leave hours and handed them over.
But if it confines it to things that are themselves would satisfy your view of what the public purpose requirement would be, it doesn't really matter, does it, that you can't control every minute of every hour?
Of course, Your Honor, we're not saying that the gift clauses require babysitting grown adults, but there does have to be some.
I guess what I'm trying to find out is there anything you think that it could be, if you could just draft what those requirements are for what the president and the other members could do using leave time, this kind of leave time, is there anything that could be in the list that would indeed satisfy the public purpose? Or are you just saying no matter what they did, just inherently the fact that it's a union and they're doing it in some ways in conjunction with the union, that is just disqualifying ipso facto?
Your Honor, even if there were such things, there would still be controls problems because, so even assuming that the answer was yes, and that's a little bit of a tougher question because, you know,
Well,
on the one hand,
can I just get whether the answer is yes or no?
The answer is, on balance, not really, Your Honor.
There's
because,
nothing that could be on that list.
Well, the things that are in the list now don't meet that requirement. Collective bargaining, for example, on the one hand, the legislature has said that it's the public policy of the state that firefighters have the right to bargain collectively. We'll note that what they don't have is the right for the taxpayers to pay for them to bargain collectively. But also, as the U.S. Supreme Court noted in Janus, unions can take lots of very political positions in collective bargaining situations that that serve the interests of the union and not the taxpayer at large. So on balance, collective bargaining is a little bit of a closer question in our view, but probably not for collective bargaining. ADR and grievance proceedings have the same kind of maybe but not quite answer.
Would it be
because-
useful for the government to have a single voice that collects the collective view of the firefighters writ large about safety problems, operational considerations, improvements that could be made in responding to claims of fires, and being able to channel that through a single voice to the fire department leadership, as opposed to just having, scattershot comments, for example, from the fire? Would that be something that would be of use and would require some organization separate from individual firefighters?
So long as the point of that was not to do things for the union or to do things for a private entity while doing so, but that the point was to serve the predominantly public purpose that Your Honor is referencing. I see that I'm about out of time, so if the court has no further questions.
I do.
Yes,
Is there
Your
an easy way to carve out the sort of welfare payments, transfer payments to individuals that I was discussing earlier?
My answer to Your Honor's question about school choice, which Your Honor was mentioning earlier, would be that in terms of gratuitousness, which you and Justice Boyd were asking about, if the government's taking money and handing it to a provider of educational services in exchange for the provision of those educational services, we would say that's consideration.
Yeah, but what if it's handing it to the student or their family? For the student or the family to then choose where to spend it, which school to attend?
Your Honor, I still would say that wasn't gratuitous, because in the end, what is being received is the provision of educational services. So there's consideration there, and it's serving the predominantly public purpose of
Right.
educating.
So what about
school
just
children.
cash welfare? Or payments to businesses during COVID?
Well, as far as payment to businesses during COVID, as Mr. Riches mentioned earlier, there's an exception in the Constitution for economic development and things like that. So payments during COVID could fall under that as well.
Maybe. What about just welfare?
I have the same answer as Mr. Riches earlier, Your Honor.
Is there an exception for that? It seems like there are so many exceptions.
I don't recall one off the top of my head. I believe the legislature's passed one, Your Honor, but I'm not recalling that statute off the top of my head. But that's just shooting from the hip, my bare recollection.
Do you have any, please?
Go ahead.
I was just asking if you had any concern that if we were to rule in your favor that a host of statutes might suddenly be challenged as unconstitutional and successfully so.
No, Your Honor, we don't.
You think this is a one-off?
We think that this kind of arrangement is unique. This kind of contractual arrangement with the union is unique because of the way association leave is structured and things like that. But we're not concerned about the people challenging different statutes, no.
Any other questions?
I had just one last one. The brief that you submitted begins with a representation about the original public meaning of the gift clauses, which is markedly different from our precedent and the whole framework that we've been arguing about today. The position that the state takes at the beginning is to say that the Texas Constitution's framers intended to limit public aid to private interests regardless of the aid's purpose. That is, even if a public purpose was present. If that genuinely is the original public meaning of the gift clauses, why are you arguing for us to instead follow precedent that clearly departs from that? Why are you not arguing for us to actually follow the Constitution?
Well, the main reason, Your Honor, is because I had limited time today and wanted to present the court with the cleanest, most straightforward way to preside the case. But the state has not taken the position that the public purpose requirement that we talk about in our brief is meaningless. What we've suggested in our brief is that public purpose requirement matters. Texas Municipal League and this court's precedent for over 100 years makes that clear, that the public purpose requirement is a vital and indispensable part of the gift clause.
So I'm trying to understand, your brief makes this original meaning argument and then immediately shifts to the thing that we've been discussing today, which is, yes, set that aside. Set the original public meaning aside. That clearly is not workable. Now let's just talk about the precedent. Is that the state's position that the original public meaning is in fact what you say it is, but we should disregard it? Instead, we should stick with precedent that allows transfers as long as they have the three features that we've been talking about?
We're certainly not advocating that the court overturn Texas Municipal League, so it would be closer to the latter thing that Your Honor said.
And why?
Well, partly because it's the court's precedent and we're not going to ask the court to overturn it. And in addition, the public purpose requirement, the way I understand the history, seems to have been grafted on still fairly early in the gift clause's history, not that long after they were ratified. And it also does track with the gift clause's text. Article 16, Section 6A says no appropriation for private or individual purposes. So that indicates it does have a textual hook as well.
All right, so maybe the original public meaning is closer to our precedent than
Yes.
we might think. Okay,
Yes, sir.
based on that. Okay, that's all I have. Thank you.
Any other questions? Thank you, Ms. Baumgartner. We'll hear from the respondents.
May it please the court, Ms. Noble and Mr. Matula will present argument for respondents. Ms. Noble will open with the first 15 minutes.
Good morning, and may it please the court. The petitioners here have asserted that Article 10 of an otherwise valid contract between the AFA, the Austin Firefighters Association, and the city is an unconstitutional gift of public funds because it provides for a pool of leave to be used by the city's firefighters. Notably, at issue here, the trial court's findings of fact are not in dispute, and instead, the legal conclusions are being challenged. They're being challenged in a vacuum. What's clear from the briefs is that we're regularly ignoring what was found through discovery, through trial testimony that resulted in both courts who have heard this case to determine that the provision at issue does not violate the gift clauses. When the contract generally is looked at, or even Article 10 specifically, though not legally required, it is clear that there is adequate consideration and that the Texas Municipal League test is met.
Is whether the consideration that the city receives is adequate for constitutional purposes a fact question?
Well, the facts in this case demonstrate that the consideration is adequate.
And you think that the question whether the consideration is constitutionally adequate is a fact question on which we should defer to the trial court?
It's the law applying the consideration test is met by the facts that are set forth in this case. You look towards whether there's valid and adequate consideration, and when you look at the facts of this case, a collective bargaining agreement, generally and specifically Article 10, where at the negotiation table there was a specific bargain made for this pool of leave. The facts here meet the test for consideration, for adequate consideration in a gift clause challenge.
In contract law, a peppercorn can be adequate consideration. Is that the way the gift clause works, do you think?
Well, I think we look to contract law when looking at this, and I think that's one of the things that gets lost in the shuffle in this case. We are here talking about a contract. We're not talking about something for nothing. We're talking about something for something else with plenty of strings attached. And so in this case, where the firefighters of the city of Austin agreed to provide services for the city of Austin and agreed to the terms of the collective bargaining agreement, which includes specific concessions that were made by the firefighters that were advantageous to the city, specifically the section of Government Code 143, which gives the cities more rights than it would otherwise be entitled to legally.
Isn't that going to be true of every collective bargaining agreement?
Not necessarily, Your Honor.
There's not benefits for both sides.
Oh, right. In terms of benefits for both sides, absolutely. A contract will include.
So it doesn't matter what's in there as long as there's benefits for both sides.
Well, as long as the consideration.
So then the gift clause has no meaning.
No, I disagree, Your Honor. The gift clause requires, under the Texas Municipal League standard, consideration or, we've advocated that it requires or the public purpose test, predominant public purpose.
What if our precedent says that those both have to be met?
Then, Your Honor, this case meets those in spades. The facts of this case demonstrate, adequate consideration, sufficient consideration, a bargain.
To whom?
There's consideration from the firefighters to the city and from the city.
Why does it have to be to the city? should it be to the taxpayers?
The consideration is there as well. The firefighters provide a vital public service to
Sure,
the taxpayers.
but how does this leave provide a vital public service to the taxpayers?
Absolutely. A question was asked earlier about public purpose and what do we look to define public purpose. We look to the legislature, and in the Government Code Section 174, the legislator determined that collective bargaining specifically benefits the public because it's a fair.
Does public funding of collective bargaining benefit the public, or does collective bargaining benefit the public? Because those seem like two different things.
Well, I think, Your Honor, public funding when it comes to public employees is part of the exchange. Public funding is used to pay the employees for their services, and the services are then provided to the city and in turn to the public.
So say if the city of Houston was negotiating with the Houston Rockets for a new stadium, would leave granted to city employees to attend Houston Rockets basketball games and then to negotiate against the city in its efforts to secure the best deal for taxpayers for a new stadium? Would that be sufficiently a public purpose and not run afoul of the gift clause?
I'm not sure I'm following where the consideration is there. This is in the hypothetical, the city is contracting with its employees and with the.
So city employees are bargaining for their employment against and secure, the concession that they can attend Rockets basketball games and also negotiate on behalf of the Rockets against the city to secure a new stadium.
I see. So one of the benefits they've negotiated for is the ability to use leave to attend one of these games. Well, I would note that that's probably not much different than an employee who is able to use vacation leave to attend such a game. So, I think there you would look at, I think the public purpose there is the employees having time off to rest, recuperate, and to do things such as attend a game.
So I think the other side would say, well, if you house that leave with the Rockets, that's the problem. How is that different?
I understand. Your Honor, in this case, the leave is not housed with the AFA. No leave passes to the AFA. It is taken by individual firefighters, both union members and non-union members, for the purpose specified in Article 10. And so this is not a situation where any funds or leave is passing to the union. It is used by city employees subject to the controls outlined in the collective bargaining agreement.
Why does it have to be leave? If it's such a public purpose, why can't they just do it as part of their on-duty time?
I'm not sure that's part of the record in this case, but my guess would be because of the unique nature of firefighting, 24-hour shifts for a lot of the firefighters, and understanding in advance who may be on leave at certain time periods.
Well, I'm just saying, rather than have a separate category of leave, why couldn't a firefighter just say, well, as part of my next week's shifts, I want to spend 8 hours doing whatever the things are that are allowed? Would that be problematic because these firefighters are supposed to be firefighters and not doing these other things, and that's why we need the leave, or is there something else to it? I'm just trying to figure out if it's really such a clear public purpose, why do we have to have this whole separate category? Why couldn't the union president, without using leave time, just be using his time as a firefighter to do all of this?
There were facts in the case, Your Honor, that demonstrate that there was a public purpose to the leave itself, and that had to do with the ability of the city, with respect to Chief Nick specifically, to communicate with him, immediately and quickly and expediently.
All that would be easier if he wasn't on any kind of leave, wouldn't it? If he's just on duty.
Well, I think in this particular case, the bargain was reached so that he would be immediately available without, the department requiring someone to cover or anything like that. This permits.
I'm not saying that his duty would be that he'd be out on fires. I'm saying exactly the things that he's using ABL for, he would just be an employee of just doing it on his job without taking leave at all. If it's a public purpose to do it with the leave, why wouldn't it also be a public purpose to do the same exact things without leave? That's the question.
I think it would be, Your Honor. I think it's the same public purpose analysis. It's just the mechanism for, you know, the taking the leave versus being on regular duty. I don't think it changes the public purpose analysis at all.
Would it be different? What would be wrong with this situation? Suppose that instead of having all of this leave being devoted just to union business with the articulated reasons, I get all of that. What if just that amount of leave was given, divided up among however many firefighters there are, and if those firefighters say, you know, it's just really important to us that our union have this kind of time to be able to do things, we're going to donate this amount of time. Would that be a functional equivalent? What would be wrong with requiring that to be the way that it works?
Well, it's not what the parties here bargained for, but I certainly think there's no problem with that under a gift cause analysis, just like there's no problem with the sort of situation described in Article 10 where there's a bank of leave.
Well, the hypothetical I gave you, I think, has much less of a gift clause problem because it's clearly then just I got this leave. If I want to use it, I can use it. If I want to give it to the union for its purposes, I can do that. That's my independent choice. That's not mediated by a requirement. The situation we have in Article 10 at least poses the concern that the union has extracted this for itself, including from people who are not union members. And that's where the gift clause problem seems to come in. Why not avoid all of that and just say, look, you know, no doubt that these many members of the union will want this to happen. Very easy. Just give them the choice, let them donate if they want to, and we're done. We don't have to have all this litigation, all these concerns. Why would that not be a sensible way to understand the gift clause in our state constitution?
I don't think it's an unsensible position at all, but I think that the public purpose here, with respect to the balance of the bargain that has been achieved as part of the collective bargaining agreement, is present and doesn't, you know, create a gift clause problem, because again, we look to the legislature who has specifically described that the ability to collective bargain in a fair and expedient manner serves a public purpose.
So if collective bargaining serves a public purpose, could the city just pay for the union? Just say, we think the union's important, we think collective bargaining is important, we think these are public purposes, and we're just going to write I don't know what the union's budget is. The city's just going to write a check and pay for the union itself. Can they do that?
There may be First Amendment implications to that, Your Honor. I'm not sure.
You don't think that'd be a gift clause problem? Just here's several $1 million to run your union.
Well,
have at it.
You would have to look at the consideration. What are they getting in exchange, you know, for that?
Well, you said the legislature has said that collective bargaining is a public purpose, so wouldn't they be getting collective bargaining for that?
Well, Your Honor,
under your view?
Your Honor, I think the collective bargaining is a public purpose, you know, is sufficient under the circumstances, but I think what's being described there, I'd have to think about the balance of the bargain there. You know, the purpose.
Well, let's say that arrangement is the result of collective bargaining. The city sits down with the union, and that's what they come up with in their collective bargaining negotiation. Is the taxpayers are just going to pay for the union, so that the firefighters don't have to.
I think you would have to look there to the controls. What controls does the city exercise? In that case, there would be, you know, questions about how the city is exercising controls over that particular bargain. And so, you know, I think that question would likely be dispositive in this instance.
Is the association president governed by, in Article 10, the clause that sets out the designated or permitted uses of leave? Or is that leave, with respect to him, unrestrained?
So the union president is governed by Section 2 of Article 10. The facts in this case have borne out that he is treated a little bit differently than the representatives who use association business leave, other association representatives. He is on full-time leave. He submits timesheets weekly, but he's not required to fill out the paperwork in advance that the other association members are required to fill out in advance of using ABL.
But in terms of the time spent, is he governed by that provision regarding permitted uses? It says for other authorized association representatives. So that seems to say not the president.
Correct, Your Honor. That particular provision is with respect to other authorized representatives. That's right.
So what controls does the city place on use of the leave with respect to his job?
With respect to Chief Nix, he's a city employee. He is bound by the code of conduct that is applicable to city employees. He is.
Except that there seems to be evidence that he's not following it.
There was an instance in which he was subject to discipline for his time on ABL because, like any other city employee, he was, subject to discipline for work performed on ABL. That's correct.
So does that go to the lack of sufficient controls?
No, Your Honor. I think the controls, work when, if they're not being followed, the city is able to exercise its control and evaluate, whether discipline is necessary, or in the case of other authorized representatives, whether ABL shouldn't be granted because it doesn't meet one of the purposes in the contract. So the city retains sufficient control in this case, and with Article 10 specifically, as well as through the contract generally. With respect to Mr. Nix, he is, subject to the same rules and requirements and personnel policies and training requirements as any other firefighter within the department.
If we understood our gift clause to another synthesis of what it requires to say that a public expenditure that goes to a private entity or the control of it goes to a private entity will be impermissible unless there is no other way to achieve the valid stated public purpose other than giving it to this private entity. How would Article 10 fare?
Well, I noting that that's not the Texas Municipal League test, I think, and again, it would also inhibit the ability of the parties to enter into a contract of their choosing. I'm not sure of the answer to that question. I'm not sure if that's.
Well, it would boil down to, is there some other way to achieve the stated goals? So without saying that your goals are wrong, assuming for the moment that all the things that you think are valid are valid, the ability to do all the things that are done during leave time. Going back to the question I asked you, I would assume that your answer would be, well, if that were the test, you're saying it's not, I agree, that's not how we formulated it. You would have to at least agree, well, that would fail the test because we could let the individual firefighters donate their time back and then still achieve things just as well as if the city does it directly in the way it does.
Yes, Your Honor. There are other ways and other types of contractual provisions that can achieve similar goals.
Whereas there might be some things in the law in which there really is no other way to achieve the public purpose other than having some private entity or individual. This may relate to the healthcare. There's no way for individuals to all to have a same mass manager for the efficiencies or vouchers for schools, things like that. That test might help sort some things out. Is that not true?
Well, I don't know necessarily that I think that test stems from the gift clause analysis or the Texas Municipal League standard. I think that test may be too restrictive on the abilities of the parties here to sit down and negotiate a contract where they determine, what's in the best interest of the city and its firefighters.
Any other questions? Thank you, Ms. Noble.
Thank you.
Mr. Material, we will hear from you.
May it please the court. The petitioner's theory of an unconstitutional gift being given by the city of Austin to the Austin Firefighters Association does not fit the facts and conclusion reached by the trial court in this case as informed by the evidence presented and the law governing the issue. A size 11 foot cannot be fit into a size 9 shoe. At least you can't do it without changing the label or mangling toes, and neither is a good idea. Here's why it's not a good fit. Number one, no city funds were actually spent on being paid to the Austin Firefighters Association. I think in many of the other cases that the courts have examined, they involved payments that were explicitly specified as gifts by the government entity to a private organization. Even in the two cases that counsel for the petitioners provided to the court here recently. In both of those cases, the government was providing money. In one case to a gun factory and to another case to a commercial real estate developer, providing money to those outside organizations so they could accomplish what was described to be a public purpose.
You don't think that providing hours that are themselves convertible into money when a member will use the hours and then get paid for that, that's functionally equivalent to giving money?
I do not believe it is the functional equivalent, because what informs the court's analysis on this issue is whether there is a public purpose involved. And
well, that has nothing to do with whether it's money. Your point, I thought, was this is not just a gift where we're just saying, here's $150,000, as in the Fifth Circuit case. This is, well, we're making hours available for a particular purpose that must be used for the union, instead of giving the union the money to then hire people to do those things.
With regard to that example, with the city giving money directly to the union, I think that is not really what is at issue in this case either, because that particular scenario seems like it would depend on, as counsel pointed out, a lack of control. That example seems to look more like the traditional cases, and the cases that were recently provided to the court, where essentially money was given by the city, tax revenues, to these organizations to do certain things which were viewed to be supportive of a public purpose.
One of the interesting things about money is that it's fungible. So there are a lot of different ways that you can effectively give money to people without handing them a check, like a tax abatement. And so are we basically not going to have the gift clauses anymore as long as people are careful about how they draft these things?
No, I believe the gift clause embedded in the Constitution serves a valuable purpose. It provides some oversight on the government on giving things away when it doesn't get anything in return.
Giving things away, not just giving money away, like hours of employees' time.
Well, things in the general sense would include almost anything, including time, but we're not giving time away. The city is not, by virtue of the ABL, giving time away to the organization. It is providing a benefit to employees who can use the Associated Business League for specific purposes.
So if the contract said that the city will provide, 5,000 hours of employee time that can be used to serve the Catholic Church, would we say, well, that's just time for the employees, no benefit really, not giving anything to the Catholic Church?
I believe that specific example might involve some other constitutional issues.
All right, the garden club of League City, Texas.
Well, garden clubs, I would not deny that they serve a valuable purpose in some regard, but what overlays the situation.
You're defending my hypothetical as something that would be okay?
Well, I think what is important to keep in mind is the legislature has determined that the public policy is favored by police and firefighters being able to collectively bargain the terms of their employment with the government entities that employ them. And they determined that because, according to the legislature, Section 174 of the Local Government Code, it is determined that discourages strife and unrest among those employees, which could injure public safety.
But that's a statement about the ability to do it, right? They're going to be able to do it, which seems a long distance from what we're talking about here, which is, are the taxpayers going to pay for them to do it?
Well, in this particular arrangement, the taxpayers are not paying for them to do it. I believe what is being...
Providing valuable consideration in furtherance of their doing it. I mean, there is value in these hours, as I think we all have to acknowledge.
Well, I believe it's important to keep mind of the fact that you have to look at the contract and the agreement as a whole, to take a microscopic view, to look at one specific provision in this agreement and say, we don't believe that specific provision is supported by sufficient consideration. And again, this court does not require equal consideration, it requires sufficient consideration. I believe if we're getting very close to opening a door that invites litigants to come into court and challenge any number of government contracts, not just municipal contracts, but county and state contracts as well, under the gift clause, with the idea that, well, even though the stated public purpose was consistent with the with the policy that favors it, we believe that this particular provision, the government is not getting sufficient consideration in return. We're going to ignore looking at the agreement as a whole.
Well, I hear you with the door opening. I'm very concerned about that too. But if we don't have some ability to look at individual provisions, then the hypothetical that was in one of the reply briefs about the Ferrari for, you know, a union leader or something like that, just as a part of this, well, it's part of a large contract, and, you know, the contract is supported by consideration on both sides, and who's to say that wasn't a, you know, a bargain for part of this agreement? That would seem as though the door that's being opened in that case is in reverse. We're creating the ability to insert obvious and overt gifts just under the guise of being part of a larger package. That seems problematic too. What's your response to that hypothetical from?
Well, my response to that hypothetical is that that focuses back on the control element. What is the control in this specific agreement that allows the government to maintain some oversight into how this use?
So it would be okay to give the Ferrari to a city employee as long as they check that it's being maintained properly?
No, I don't believe that's the case.
So what kind of controls would allow the Ferrari?
Off the top of my head, I would not, I couldn't.
But the point is, you think it'd be controls about the Ferrari, and so you're agreeing that we can look at provision by provision of the contract, at least for the control purpose? I mean, you said that the problem is we're getting into the gift clause and we're dividing up and severing out Article 10, but if the Ferrari can be separately analyzed for purposes of are there adequate controls and stuff, it seems like you're agreeing with the other side's point that we can look provision by provision.
I think there would have to be a legitimate and reasonable determination that the gifted Ferrari would serve some public purpose, some legitimate public purpose, and not just some lip service statement that was put into the title.
But that's your friends on the other side's position, though, I think, is to say, well, we need to look and see whether the provisions of Article 10 individually serve some legitimate public purpose. So it sounds like maybe the dispute doesn't actually concern whether or not we can look at just Article 10. The dispute is whether or not Article 10 satisfies it. Is that fair or not?
Well, I believe what I'm trying to express is Article 10 is a concession within the agreement made between the city and these employees. These employees, like any employee, their employment can be terminated by the employer, in which case if that employee is terminated, that employee is not going to get any sort of leave, associated business leave, vacation leave, or sick leave, because the employment relationship is no longer going to exist. I think the idea of giving an employee a Ferrari, I mean, once you give the employee the keys and the title, I'm not sure what one does to get the Ferrari back. I don't know if that specifically addresses.
Maybe you have a lien.
Pardon?
It's not important.
I believe.
Any other questions? Thank you, Mr. Bertuzzi.
Thank you.
Mr. Riches, you have 5 minutes.
Thank you, Mr. Chief Justice. Taking the consideration question up first, because there was a number of questions along those lines. Even under normal contract law, there must be contractual obligations. This court has said that for over 100 years. And then in the gift clause contexts, other lower Texas courts have said that very directly and have struck down deals when there are no contractual obligations. The key case is the best example. Just last month, the Corsicana case, the Court of Appeals in Waco said that an agreement or contract that imposes an obligation on the recipient to perform a function benefiting the public is required. So that's the easiest test that has been applied and ought to be applied on the consideration question. And here there simply is no contractual obligations. The union time is given to the union, and they can use it whenever or however they see fit.
Don't they make a good point, though, that you have to look at the entire thing, and if you were to just take Article 10 out, which I take to be your position, well, who's to say whether the agreement would have been formed or not? That might have been something that was of sufficient value to the bargaining side opposite the city, that without that, some other structure, we can't just pull it out and assume that everything else would stay the same. How is it that the courts are supposed to be able to assess that?
Your Honor, I think we have to look at who the recipient of the gift is and what they're doing with it. In this case, the recipient is not all employees. The recipient is not the public. The recipient
the leave is available to all employees. Now, some may choose not to avail themselves of it, just like some choose not to avail themselves of health insurance, but it is available to all employees.
I think, Your Honor, we have to look at the reality of the transaction. And for example, when it comes to Mr. Nix, he is on full-time release. Nobody else can use that. And he uses that whenever and however he sees fit for political
Well, that's
activities.
interesting because it looks like at the beginning of Clause 2 that talks about permitted uses, it talks about authorized association representatives other than the president. But then it goes on to define association business, and if you look at the provision specifically for the president's limited to using ABL for lawful association business. So
Correct.
is association business that business that's defined in subsection 2?
No.
And that then sets out the guardrails on the use of that time.
Your Honor, as tenuous as those guardrails are, they don't apply to Nix. B1, Nix can use it for any lawful association business. I would direct the court to 2 SCR 446, 26, 6-7, where the union president testified that business leave means leave that can be used to do association business. The city says at 2 SCR 615, ABL means leave that support the AFA's role as an employee representative. So we know that it's just for association business. And the record is also
But
predominantly
in the
clear.
agreement itself, it defines association business. Association business is defined as time spent in collective bargaining, negotiations, et cetera. So are we supposed to read that out of the clause?
No, Your Honor, no. And I think we have to give the clause its plain meaning. But then we have the situation which exists in this case where 96.4% of all ABL is used for union conferences or meetings, recruitment activities in the amorphous, undefined category of other association business. So Your Honor asked, what's a public purpose if you're trying to balance predominant? 96.4% for meetings and other association business is not, on this record, a public purpose and simply can't be.
Can you address the concern that your friend from the city raised, which I share, and that is that if we were to rule for you on the grounds that you stated, seems like courts are going to spend an awful lot of their docket time scrutinizing every manner of government contract, provision by provision, to go through this assessment. Now, maybe that's a feature. I think it's probably a bug, but tell me, is it really going to happen, or is it, if it does, is that a good thing? Tell me.
Well, I mean, Your Honor, this court has already said that the gift clause has very modest requirements. Public expenditures have to be for a public purpose, the government has to control them, and there has to be contractual obligations. If an agreement fails that very modest test that this court has already laid out, and this agreement fails it miserably, then the agreement should be subject to scrutiny. But we don't think it will open the floodgates to litigation because the test already exists, and we haven't had a major gift clause case in 30 years. To the control element on which there was a number of questions, this relationship is unlike any employer-employee relationship anywhere in the private sector or in government service. Under Texas law, an employer must be able to have the right to supervise an employee and the right to set the employee's work schedule, to hire or fire the employee. None of that applies to Mr. Nix, who sets his own schedule, directs his own activities, doesn't receive any prohibitions from the city, and effectively uses this leave for any purpose he sees fit. That is inadequate control under any circumstance, and it certainly is under the gift clause.
Any other questions? Thank you, Mr. Riches.
Thank you, Mr.
The
Justice.
case is submitted, and the court will take a brief recess.
Rise.